While the celebration of an historic and precedent-setting court ruling was taking place here in Duncan, the impact is being felt 90 kilometers away across the water.
The courts remain an option for First Nations when we are not heard and our rights are ignored. We did not pursue this case with malice or ill will.
The BC Supreme Court finding the Cowichan Tribes have the right to 7.5 square kilometers of their old grounds, now part of Richmond, determining land titles previously granted by governments, including private property, are, quote, defective and invalid.
We're not here to fight against anyone. We're here to ensure that history is in its right place, that history is corrected.
The BC government will be appealing this decision, and ultimately it is expected to end up in the Supreme Court of Canada. Eby, in a statement last week, says he is deeply concerned around the ramifications of this ruling on individual private property rights.
The ruling could have significant unintended consequences for fee simple private property rights in BC, and that must be reconsidered. It'll be amongst the arguments that we will be making in our application for appeal.
On Monday, both the Cowichan and the provincial government expressed an interest to talk face-to-face, but experts say the province's deals with other First Nations complicate the issue.
So you look at the Haida Recognition Act, where they themselves voluntarily, outside of courts, overlaid Aboriginal title on private land. Those two things are fundamentally irreconcilable.
Conservative leader John Rustad says this ruling, even with an appeal, will already have a significant impact.
These title cases, particularly now with private land, has put an incredible chill on British Columbia, on the ability to invest.
With the legal cases continuing, the Cowichan Tribes will now have to wait, drawing this out after they, in their words, have waited more than 150 years due to government lawlessness. Richard Zussman, Global News, Duncan.
And Keith Baldry is here with more on this. Keith, it's a tough position for the provincial government to be in. What are the implications we're looking at here for the NDP?
Yeah, it was apparent very quickly upon release of this judgment on Friday in conversations and texts with cabinet ministers, senior government officials. This appeal was a no-brainer. The NDP could not risk being seen as not taking on or opposing a judgment that so blurs the lines between Aboriginal title and private property rights. So it was just a matter of time before the NDP was going to launch this appeal. We expected it today, as early as today, and that's certainly what happened. Attorney General Niki Sharma says her legal team thinks there's a considerable number of grounds here to support an appeal. And she also says the government's still willing to sit down and negotiate some sort of settlement. Here's the Attorney General.
Our team is working through what we think are quite a few grounds of appeal, potential grounds of appeal. It's not unlike many very complicated cases related to rights and title that make their way through many appeals and usually through to the highest courts of the land to help us all clarify legal issues that we need to have clarified by the courts. In the meantime, we are open to sitting down with nations in this province to make sure that we can come to agreement in a more certain way through our reconciliation work.
So it's also not clear yet whether other parties will appeal this. Of course, the BC government was just one of 6 parties in this land claims fight. We also have the City of Richmond, the federal government, the Vancouver Port Authority, the Quw'utsun Indian Band, and the Musqueam Indian Band. And we talked to Chief Wayne Sparrow of the Musqueam on Friday. He was quite upset over this ruling. So it remains to be seen where others will join BC in appealing this landmark decision.
All right, thanks for that, Keith.